The first matter to come before the court this morning is State of Ohio versus David Smith. The appellee has waived oral argument in this case. You have 15 minutes.
Thank you.
We've read the briefs and we're ready to proceed when you are.
Morning, Your Honors. May it please the Court, I am Alan Medvick. I represent David Smith, the appellant, in this matter. Mr. Smith has raised two issues on appeal in this case. First, whether the trial court abuses discretion in failing to conduct a hearing on the trial counsel's motion for regarding the competency of the defendant, and secondly, that the verdict was based on insufficient evidence to find guilt, and that the defendant's Rule 29 motion should have been granted and was improperly overruled. Regarding the first issue, without appellee's counsel here, we rely largely on the briefs on that matter. The arguments are largely that there was a motion for competency that under statute requires a hearing. No such hearing was conducted. I believe that the...
What do you think the hearing should have looked like?
I think there should have been some record. I believe that what was conducted was an in-camera... My review of the record looks like it was an in-camera review of one telephone conversation with virtually no cross-examination, no argument on the part of defense counsel, no argument presented to really substantiate what her basis for that motion was. I'm not claiming that there should have been days of evidence heard, but I think the trial court fell short of what their obligations were here.
The reason why I was asking is because it sounds like it may not have been an evidentiary hearing where people were sworn in, but counsel did argue why he thought he was incompetent and explained what indicia of incompetency he witnessed.
And I understand that. I believe that there should have been something, probably for just this reason. If there was an issue of competency, that the possibility of having that available on appeal is foreclosed at this point. I think that there's no record of what those arguments were.
So you're saying the argument that counsel had
I think that counsel may have,
not on the record?
I think counsel may have had some opportunity to put additional evidence on. Again, I don't want to bog down on that point, because I think that the greater matter, and regardless of the competency issue, is that there was insufficient evidence to sustain the robbery verdict in this case, based on a failure to show force or threat of force by the defendant in the act of theft offense.
I don't mean to monopolize the questioning here because I've got a big mouth, but I'm just wondering because the state said, and I think you mentioned even in your facts that he was pointing. Do you know what the record? We'll obviously review the transcript and the record, but at least I haven't done so at this point. In what manner was he pointing? Do you know? What was the testimony in regard to that?
And that I'm unsure of. I don't believe that he was. I believe he was pointing toward I think his note indicated that he wanted bottom drawer 50s and 100s. My recollection of the record is at any point in relation to that drawer. I don't believe there was a threatening manner, but that won't show up on the record.
Like his hand in his pocket, like he's got a gun.
And I don't think there was any implication that was what was happening. I don't think that's in the record anyway, that there was an effort to show, again, I'm doing record of that. In fact, I think that all of the evidence seems to indicate there was no actual language of force or threat of force. I believe that the teller indicated that the man was large, and that basically her corporate training was to treat any such request as an implication of force. I'm not saying that such corporate training is a bad policy from I don't want to belittle this and calling it a customer service and corporate decision, but I don't think that rises to the level of implying objective findings of threats of force.
Could the force have been elbowing people out of the way to get to the counter?
There was one, I think that there was one instance where one claimed that the person nudged someone as he was walking up to the window. I don't think that rises to the level of force at issue here. The Ninth District has actually defined force to be to imply either to be a threat of harm or that's the Carter case, that there has to be a threat of the force has to pose actual or potential harm. I think there's one point where he actually says, "Excuse me," while he's walking past someone, which I think would kind of imply that he was not intending to use force at that point, and that there's not the kind of force that the robbery statute encompasses, or that the force statute is meant to indicate. And there's other case law out there from both the Ninth and other circuits, the Common case as well, which I cite, which addresses that issue. And I think that the other matter that the state raised is this implication of force just by the note, by the mere presence, the circumstances thereof, but the note and the circumstances here are distinguishable in that every case the state cited, the note contained some language to hold up to robbery, to an implication that there was a weapon involved. Here, this was not such. That there was a note that said, "Give me bottom drawer 50s and 100s." That was the extent of it. And I think the implication of force there would go too far. I think there has to be more, a showing of some kind in order to find a robbery here. I think it was, it's unquestionably a theft, but that implication of force, I think, is not met. Again, I would usually have reserved some time here. I think that the matter pretty clearly falls on that issue that you were looking at, and I don't think there's any witness to demonstrate that there was an act of force. I don't think the man was acting violently. I don't think the man Mr. Smith was throwing his arms around. I don't think that he didn't try to come over the wall at the teller station or there's nothing in the record outside simply the teller, Ms. Henkel's subjective belief that there was a weapon or something involved. And I'm not sure that subjective belief is reasonable under these circumstances without something more, without something in the record. Without further questioning, I think I would rely on my briefs from here forward.
Thank you, counsel, for your presentation. The court will take this matter under advisement, issue a decision to be mailed to both sides as well as posted on our website and the Ohio Supreme Court website.